Okay, the meeting will come back to order, and we'll start with agenda item number 9, which is discuss and take action on proposed orders of amendment to existing TCO rules. Mr. Beecham.
Thank you, Chairman. We're looking at 4 proposed amendments, Commissioners, this morning. Separately, I'll defer here in a moment to Director Grigsby and Director Merchant to introduce briefly each one of these rules and what the purpose of the rule is. We'll take proposed amendment number 1 separately and 2, 3, and 4 together. If you look at 2 and 3, you'll see in your packets 2 is just a repeal, 3 is just a replacement of 2, so they're broken down pretty simply. Let me give you a little bit of background briefly. The process that we're using as a reminder is we take Rules Committee comprised of staff, and as we discussed during the strategic planning session, as the situation may warrant going forward, invitation to outside parties, the regulated community, and the public, where that may be necessary in the future to be part of the Rules Committee. However, these 4 proposed amendments before you this morning were comprised solely of staff because apart from 1, there are no new substantive changes. We just have some clarification, recodification, in things of that nature. With that being said, I'll turn it over to Director Grigsby to introduce proposed amendment number 1.
Hello again, Commissioners. So under proposed rule number 1, we are adding a definition of not only police chief, but police department. This was the result of a conversation with LEMIT to clarify which agency heads are required to go through LEMIT chief's training. And so the police chief is defined in statute. This adds a clarification of what constitutes a police department and what it does and does not include.
Discussion or questions on proposed amendment number 1?
Mr. Chairman.
Commissioner Hester.
So for number 49, the definition that's in here, well, first off, as a matter of procedure, we're voting to post these on the register?
Yes. Correct. This is the first reading,
so this
Commissioner
is the first,
Hester.
So I just want to make sure everybody's on the same page. This is not to vote for final.
Correct. This is a proposed amendment. This is the first public reading. And today, Commissioners, if you vote to move forward with these rules, they'll go to the register for public comment and be taken up at the next commission meeting for final adoption, at least for consideration for final adoption.
Okay. On the definition of 49, you referenced that it was in statute. Is this language a copy of what's in statute, or did I misunderstand what you said?
It is essentially a copy of what's in statute. It says in this section, police chief, in quotes, or chief means the head of a police department, but does not give a definition of police department.
Okay. And when we talk about on police department, there might be some confusion on my part, and maybe we have a commissioner up here that can clarify this for me, because it's probably in her bailiwick. But when we talk about a police department and a public or private institute of higher education, and then it goes on to say this does not include state agencies, are we talking simply which higher education, institutes of higher education are we trying to refer to in this?
I'll be glad to address that. And I'm going to back up just a minute to give you a little background leading up to it. We kept hearing from both people that are wanting to attend the LEMIT Chiefs class and from LEMIT that there was no clear picture about who was actually required to be there. They let some people attend that are not necessarily required if their position kind of calls for it. But who is actually required, that clears up for us who we do for non-compliance on who has to be there. So we held a meeting in College Station with the Chiefs Association, with LEMIT, and with us to hash this out. Police, we are trying to draw a distinction between police department and law enforcement agency. And the code is in the education code where the actual definition of the police chief is one of the, and we We chose to go with that definition, but it just said the chief of a police department. So we tried to go mainly with agencies that are titled police departments that do police functions. And ISD and higher education police departments do those type of functions. They have, most of them have patrol functions. They have the same type as a municipal police department. It was pretty clear since talking police chief that it did not intend all law enforcement agencies, so we left out any county agencies, we left out any state agencies, and left this as purely municipal and education police departments. And honestly, it didn't have to just be that way, but it was the clearest way to do it, and it helped us establish an absolute list of who needed to attend that training under the law. So it includes all higher education institutions that choose to have a police department, whether public or private.
But is I guess it's not considered a state agency, would that be correct?
I would consider the different systems are considered state agencies.
They are considered state agencies, but it is also and maybe we can clarify that I see what you're saying, and I know where the potential conflict is.
Right.
We can clarify that you're looking at a state university. Do you consider them a state agency, or do you consider them a higher education? We have chosen to move them into the higher education part where they need to have it because they're police chiefs and they need to have the training. So your point's well taken. I think we can clarify the wording that even though they're a state agency, they fall under the higher education category, so they are included. We can do that very easily.
So you're basically saying that by virtue of being a higher educate or an institution of higher education, that trumps the wording.
Exactly,
of the state
and
agency.
we can clarify that
Okay.
in this public comment. We can come back that's an easy fix. I hadn't thought about that aspect. That's a very good question.
So, as a matter of procedure, do we need to make any kind of thing now, or do we go ahead and
No.
post it as is?
You should amend it the way you want to right now.
Yeah, now's the time to do it. It's easier to do it right now. If there wants to be a clarification to it or a change, now you can do it. You can make the change and make any necessary motion after you make that change to post the rule as is then. So now would be the time versus waiting during the public comment period, because there may be other changes based on the public comment, obviously. But if there's a change to clarify or otherwise, this would be a great time to do it.
With your permission and with permission of the general counsel, his approval of it, I would see the easiest way for us to take care of that for you would be to make the motion to accept it with a clarification. Trying to come up with exact wording this morning might be problematic because there's a lot of different ways we can look at it. So if you simply give us the direction to clarify that one point, I think we can take it from there and bring you back wording at the next meeting that we could approve at that time if that's acceptable.
It's up to you. If you really want specific language, now's the time to do it.
I think it needs, my issue is, I think it needs to be clarified, but when I'm sitting here looking at it as written, I can't come up with
That's
the whole deal to clarify it, so.
Then you defer to them to come up with language. We still have the opportunity when we come back for the final reading.
I mean, we have
to
like
change
4
it
attorneys
again.
sitting in the room, so I was hoping somebody would.
You can do
Well-
there's a couple ways you can do
Mr.
it.
Winter.
I have one that just handed me some wording. So Mr. Winter has said for consideration, just adding the statement when you're saying that no state agencies does not include state agencies that are not institution of higher education. In other words,
Okay,
the definition does not include state agencies that are not institutions of higher education.
Is that what we want?
yes.
Okay.
Let's do that one more time. Hey, Ray or Kim, whoever has it,
Jump in there, Ray.
please read it to me. I'll make the note, and then I'll listen to it one more time together.
My suggestion, based on what I've heard, is that you modify definition 50 of police department to read as follows. a municipal police department, comma, an independent school district police department, comma, or a police department of a public or private institution of higher education, period. This does not include state agencies, insert, that are not institutions of higher education, comma, county agencies, water districts, city marshal's offices, or any other type of law enforcement agency not listed above. So you're putting in a carve-out in the carve-out, so I think that addresses the concern that I heard Commissioner Hester articulate.
In Ray, I'm going to read that one more time, okay? I'm going to read the last sentence of definition 50, so we're, myself primarily included here, so we're all on the same page. I'm reading from 50, last sentence now. This does not include state agencies with the new insertion that are not institutions of higher education, comma, county agencies, water districts, city marshal's offices, or any other type of law enforcement agency not listed above.
That was my suggestion.
I know we have a double negative in there. However, based on, I think we have the substance of the, of what, of course, if that's what everybody, if the commissioners want that, if we have the substance of this carve-out of the carve-out, as Ray put it, we can further, we can adjust the language so it is, makes that a little bit clearer. But we have the main substance of it if that's what we're shooting for here.
Okay, so I guess my question currently, and Commissioner Lameau, are you required currently to go to Lehman?
Yes.
Yes.
That's the way I interpreted it, yes.
Okay.
Yes, she is.
I just want to make sure that by doing this, we weren't changing the practice
Yes, sir.
of how it's seen now. Okay.
Motion.
I would make a motion to approve amendment number 1 with the changes read by General Counsel.
Second.
Have a motion and a second. Any further discussion? All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. Mr. Beecham.
Commissioners, proposed amendment number 2, as you see in your backup and supporting material, this is a repeal of Rule 218.3. However, proposed amendment number 3 is a newly proposed 218.3, and I'll turn it over to Director Merchant to explain how we got here.
Commissioners, and just to expand on what Commissioner Hester just said, there is no intent behind this change to change any practice or grant or take away any authority that was not already there. So no substantive changes. This is just a compilation and an easier language to understand. Ever since I've been with TCOL, I've always known one of the things we take the most disciplinary actions on is noncompliance. There's multiple reasons for that. The attempt here is to address one of those reasons being that that training has been getting more and more confusing as more and more courses are added to the mandates. Our existing rules had mandated training listed in different locations. It used a cut and paste methodology from statute where the actual course name was not listed. It would just list a descriptive paragraph of what the course was supposed to be about instead of just saying take cultural diversity. You would have 2 or 3 sentences involved there. And another issue that prompted this was there's now differing time frames in our training. It used to be fairly simple when everything was tied to a unit, 2-year training unit or a 4-year training cycle. But in the last 3 or 4 legislative sessions, all of the add-ons have been add-ons that say within 1 year of licensing, within 2 years of licensing. So the old methodology of keeping up with training where you didn't have to worry about anything until August 31st of odd-numbered years is basically out the door. There's a lot of classes in there. What we tried to do here, and this is based on some of the feedback when we got from our tour of Texas, was to bring all the training into one location, listed in English by course name and course number, so there's no doubt what courses that you can take, and divided into categories that are easy to understand: licensing courses, miscellaneous courses, assignment-specific courses. Once again, this is no additional training, this is no changes to the requirements, it's just rewording and relisting of all those requirements in an attempt to make it easy for everybody to understand what the training requirements are.
Mr. Chairman,
Commissioner Hester.
a shocking turn of events, I have a question. Actually, I have a statement. So, first off, I just want to say I really like what we're trying to do here. As a trainer, and I think probably wasn't able to make the training consortium meeting yesterday, but hopefully everybody will like this when it comes out. But specifically on number 4, it says for the new supervisor requirement, it says new supervisors, each peace officer assigned to their first position as a supervisor must complete new supervisor training within 1 year of appointment as a supervisor. And that's actually a little bit in conflict with statute, because statute says you can take it within 1 year before appointment and 1 year after. And so I think that particular paragraph needs to have that added in there for clarification.
Correct. And I could see that. We use the within because within implies in either direction, before or after, but if we need to put some clarifying language in there, that would be very easy to do.
Yeah, so, I mean, I can see both ways within 1 year of appointment. To me, it means the calendar doesn't start until you get appointed.
Okay.
But the intent of the legislature when they passed the statute was you could get it early. So if you identify someone that is on an eligibility list, or you want to promote them, that you can get them to the training early and then get appointed, and it still suffices. So with that,
Maybe the wording within 1 year prior to or after?
Yes.
I'll just point out that within language is used in multiple of these course descriptions because they can be taken in the academy prior to getting your license or taken after, so that same terminology is in multiple locations in this change.
correct, but on this one, the 1 year before is specifically listed in statute. So it needs to be reflected here, because the other one, I don't think as much issues.
I see what you're saying.
It's an easy change. We can insert that
So,
exact
yeah, so
language from the
On,
statute.
on that one would be, it would read, on section 4, each peace officer assigned to their first position as a supervisor must complete new supervisor training, 1 year prior to, or 1 year of appointment, 1 year prior to, or 1 year of appointment as a supervisor. What does the statute say on that? You have that?
Which section is it, Commissioner Hester?
That's number, I'm sorry, that is D4, subsection D4.
I'm with you. Do you remember which section of 1701 we're referring to here?
Well, I'm not that good. I can't remember.
352D.
What we can do here is we can ensure that 4 is conformed with the occupations code. That's not a problem without us digging through the rule book right now to ensure it happens at the time. Obviously, when we post it, we can make that change because it has to conform with statute. So we can certainly make the motion there. I had, and I don't want to speak for Commissioner Hansworth, but E4, looking down at E4, there is a parenthetical with CITP, comma, and there are asterisks in there. What is the missing term? Is it a course number, course name?
That's a course number that hasn't been issued yet, and it will fill in that blank when that course number is issued. The course won't be out until September 1st.
Okay.
Yes, I'm sorry.
So for Texas Register purposes, we'll just enclose that parenthetical there, just show CITP parentheses and remove those asterisks. And I would suggest if there's a motion made to approve this proposed rule, we will ensure that D1234 conforms with Chapter 1701, and we as staff can do that prior to, because if there's a direct contradiction, if it's not in conformity with the provision, we can certainly present it to the Texas Register conformed.
Okay. My other question was on subsection G, George. And so we start getting in there about requirements and everything. It says, "The commission shall provide adequate notice to agencies and licensees of impending noncompliance with the legislatively required continuing education." And so adequate notice to me is very ambiguous and kind of, what is adequate notice?
Yes, sir. That was not an actual change, that was just a copy from the previous rule,
Right.
but if we need to
So-
add language, obviously.
And
now's
that's the language in statute
Yeah.
as well.
Adequate notice is
Yes.
Correct.
That's,
Correct. Well,
Yes,
I
sir.
mean, I think the way this plays out practically is staff notifies each agency with a list of licensees who are going non-compliant with a series of notice letters.
Practically, that comes out usually in March.
Correct.
February, so-
And throughout the summer prior to the pending non-compliance.
And so with the intent, I see the intent, the legislature says adequate notice, and then we as the commission can set the rules to more define that adequate notice.
Correct.
And what we need to be. So I guess, is there a desire to
No.
be clear, leave it
No,
alone?
no. No, the intent is for it to be adequate notice to give us latitude in instances in which we can't conform to some arbitrary deadline we place on ourselves.
I like it.
And that's,
My thoughts.
I'm sorry, Commissioner, and that adequate notice is provided through procedures such as we discussed, the notice to the agency letters with the licensees' names on there. Certain licensees are missing certain courses. That's the procedures that have been adopted to provide that adequate notice.
I like the discussion. I have nothing else to add to that, Mr. Chairman. Thank you.
Okay, motion on proposed amendment 2 and 3.
I make a motion to approve amendments 2 and 3 with the changes to amendment 3 to include subsection D 1 through 4 conform to 1701.
Motion and a second. Any further discussion? All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. Proposed amendment number 4, Mr. Beecham.
Commissioners, I just want to ensure, did we get proposed amendment number 2 to go along with 3? Because 2 repeals 3, and I'm sorry if I missed it.
Yeah, I made the motion to approve 2 and 3 with the changes.
Very good, thank you. Proposed amendment number 4, Commissioners, Director Merchant, I think you had some notes on this one as well, didn't you?
Yes, sir. Proposed amendment number 4, change to 223.17, reinstatement of a licensee amendment. This is actually a correction of a mistake. Several years ago, when we readjusted the reactivation requirements and set out specific time parameters, we failed to do the same for reinstatement, which was a mirror, or is supposed to be a mirror to those same requirements. We noticed that during a Rules Committee meeting, so basically we're bringing this back into line with the mirror it's supposed to have with our reactivation requirements.
Any questions? Motion?
I make a motion to approve amendment number 4.
Have a motion and a second. Any further discussions or questions? All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. We'll move to agenda item number 10, which is discuss and take action on proceedings for revocation, suspension, and other disciplinary action. Mr. Winter of the Attorney General's Office.
Good morning, Commissioners. Raymond Winter, and we have a number of disciplinary matters for your consideration this morning. The first items are default orders of suspension. These officers received notice from the Executive Director of the Institution of Enforcement Proceedings because the officers had committed offenses that give rise to the institution of a order suspending their licenses. These officers failed to respond to the Executive Director's notice and have therefore defaulted and forfeited the right to a contested case hearing. The Executive Director recommends entry of default orders suspending these licenses, and the officers in question are Richard Abrego, Anthony Arvizu, Jenny Ayers, Stephen Katina, Lindsay Champion, Jasmine Ellis, Albert Feliciano Jr., Colin Frazier, Stephen Heckler, Devin New, Joshua Olvera, George Reed, Sherry Saldana, Kimberly Shaw, and John Schuler Jr., Sr. We've got additional information regarding each of these cases if you have any questions, but the executive director recommends entry of these default suspension orders.
Thank you. Commissioner Hollingsworth.
I move that the commission accept and adopt the recommendations of the executive director to enter default final order as authorized under the provisions of 37 Texas Administrative Code, Section 223.3, as required under the provisions of the Occupations Code 1701, Section 1701-501, to suspend the licenses of Richard R. Abrego and through the list to John M. Schuler Sr.
Second.
Motion and a second. Any discussion? Commissioner Hester. All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. Mr. Winter.
Commissioners, the next three individuals all committed misconduct that gives rise to the institution of disciplinary proceedings to revoke their peace officer and jailer licenses. These individuals similarly failed to respond to the executive director's notice of enforcement proceedings, and the executive director recommends entry of default orders revoking their licenses. Those individuals are Oscar M. Flores, Thomas A. Reyes, and Darren D. Sells.
Thank you. Commissioner Hollingsworth.
I move that the commission accept and adopt the recommendations of the executive director to enter a default final order as authorized under the provisions of 37 Texas Administrative Code, Section 223.3, as required under the provisions of 1701, Section 1701-501, to revoke the license of Oscar M. Flores, Tomas A. Reyes, and Darren D. Sells.
Second.
I have a motion and a second. Is there any discussion? All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. Mr. Winter.
Commissioners, the next three individuals have entered into negotiations with the executive director and staff, and we're pleased to announce we have proposed agreed orders of suspension in the cases of Michael J. Baggett Jr., James B. Sapp, and Angela Sargent. And the executive director recommends that these three proposed settlements, all resulting in agreed terms of suspension, be approved.
Commissioner Hollingsworth.
I move that the commission accept and adopt the recommendations of the executive director to enter a final agreed suspension waiver for Michael J. Baggett Jr., James B. Sapp, and Angela L. Sargent.
Second.
Motion and a second. Is there any discussion? All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. Mr. Winter, the proposal for decisions.
Commissioners, the next three items are all contested cases that did go to the State Office of Administrative Hearings. There were proceedings at SOA resulting in the issuance by the administrative law judges of proposals for decision. And we'll take these up in order, one at a time, and ask for your action on each. I anticipate that there may be some interest by one or more of these respondents to address the commissioners. I haven't seen any of them in the audience today, but they may have come in before I knew it. And it looks like you have a card from somebody. The first is Robert R. Becerra. Mr. Becerra was issued a jailer license by the commission, and at some point in time subsequent to his receiving that license as part of, I believe, a routine audit, the executive director's staff discovered that he had, in fact, 2 DWI convictions in his criminal history, making him ineligible to hold his jailer license. The second was actually a third-degree felony, driving while intoxicated conviction. The executive director notified Mr. Becerra of intent to cancel his jailer license. He wrote back and preserved his right to a contested case hearing and said that he didn't want that cancellation to take place. That resulted in proceedings before the State Office of Administrative Hearings. The executive director's staff, represented by the Attorney General's office, filed a motion for summary disposition at SOA, which ultimately, after some motion practice, was granted. You have the paperwork before you. There never actually was a contested case hearing because the ALJ disposed of it on the pleadings. And so what you have before you is a proposal for decision from the administrative law judge that Mr. Becerra's license be canceled due to the fact that he is ineligible to hold it as a matter of law due to his prior driving while intoxicated convictions.
And Commissioners, I want to follow up on a note that Mr. Winter made. In your backup material, the classification offense for this particular proposal for decision states a Class A misdemeanor, but Mr. Winter was correct. It was a felony. The second DWI was a felony offense, as it shows in your proposal for decision.
Okay, I don't have anyone signed up to speak on this. Is anyone here? Commissioner Hollingsworth.
I move to accept the ALJ's cancellation of the license of Robert Becerra.
Second.
Motion and a second. Any discussion? All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. Mr. Winter.
Commissioners, the next matter concerns Joshua Grant, a peace officer. Mr. Grant was employed as a municipal police officer with Kingsville Police Department. He was arrested and charged in an incident resulting from a domestic dispute with his girlfriend and the mother of his child. He ultimately pled and received deferred adjudication for an assault charge. And the issue here was whether, based upon the totality of the evidence, the offense to which Mr. Grant pled guilty and received deferred adjudication was an offense involving family violence. There was, again, a motion practice before the State Office of Administrative Hearings after Mr. Grant preserved his right to contest the Executive Director's revocation proceedings, and ultimately the Administrative Law Judge granted the Executive Director's motion for summary disposition and has recommended that Mr. Grant's peace officer license be revoked because of the fact that the charges against him involved family violence based upon the totality of the evidence. Mr. Grant was represented by counsel. I don't know if counsel is here today, but counsel does oppose the recommendation of both the Executive Director and the Administrative Law Judge that Mr. Grant's license be revoked.
Okay. All right, thank you. Pardon me, the peppermint went down the wrong toe. We do have someone signed up to speak on behalf of Mr. Grant. If you would, come to the podium and introduce yourself.
Hello, Commissioners. Mr. Winter. All right. I'm joined today with my co-counsel, James Anders, and our intern, Jonathan Stewart. He's over there. This is his first appearance in any sort of legal matter, so I was going to have him come up here and do that. Your Honors, I think where I'd like to start is what we're asking for. We're asking for this to be heard on the merits, not to be granted under an MSJ. Deny the proposal for the decision, send us back so we can have a hearing on this. Nothing in the Executive Director's pleadings establish affirmatively that there is a family relationship between Mr. Grant and the complainant in the matter, along with establishing that the child is his child. But before we get there, what I would like to do is attack it procedurally. The pleadings of the Executive Director originally established that this was a crime that had an element of family violence. Our responsive pleadings to that were to attack that this was not an element of family violence. It's a 22.01 assault. There were no affirmative findings made by the judge in the case. There were no stipulated facts entered by the prosecutor in the case. For all intents and purposes, if you look at the judgment of the court, there's nothing that would even reference that I believe her name is Miss Ramos, Miss Emily, has a relationship of any kind with Mr. Grant other than owning a pizza shop with him. We did not object to the department's exhibits, or I'm sorry, not department, the Executive Director's exhibits, because if you read Exhibit B, which is the Kingsville Police Report, you'll find that were a dozen statements taken from a dozen witnesses at the Pizza Hut where this alleged assault occurred, who all denied that the assault ever occurred. Now, I wasn't his counsel that handled the underlying misdemeanor out of corpus. I'm only involved with the hearing before this commission. And I believe that it does not substantiate, and there's nothing in any of the exhibits that the executive director has provided that actually establishes a familial relationship, dating relationship of any kind. I think this should be heard on the merits. I believe Mr. Grant dutifully served this state and his county since 2009 with honor. This incident arose because of a scratch to an elbow, I think is what was alleged in the police report. A detailed investigation occurred by the detective for a period of 2 to 3 months, where they interviewed about, I think, 10 witnesses. I might have that wrong, so don't hold me to it. And not one of them saw that they saw an alleged assault. In fact, the complainant in this case attempted to ask the detectives to stop pursuing an investigation on Mr. Grant multiple times. I believe there is a genuine issue as to a material fact. That is the only basis for when an MSJ should be granted, is when there is not a disputed issue. I think there's a disputed issue as to what Mr. Grant pled to, whether or not it involved a familial relationship with any of the parties. I think that Mr. Grant is entitled to notice of what he needs to respond to if the executive director decides to plead that it's an offense where it's not involving family violence, but it's an offense that includes an element of family violence, then that is what Mr. Grant should have to respond to. And that's what we have responded to. There has been no amended pleading by the executive director. I feel that he's entitled to a contested hearing, regardless of whether or not we think that the facts are true or not. I don't believe we overcome the no genuine issue as to material fact or material dispute. Your Honor, I just asked for due process. I asked for a hearing on this matter. It's easy to follow the PFD. It's a lot harder to do the right thing and allow us to have due process. I think Mr. Grant's entitled to that, to have a hearing on the merits, and not just to be poured out. As this commission is aware, this type of, if this commission rules the way the PFD wants, it'll be a lifetime ban on Mr. Grant. I don't believe he can ever pursue a peace officer license again. He's not here today because he's having to work construction since he has been suspended and can't serve. He would like to get back to duty, and that's Mr. Grant has sent me here to say this to you. Keep wanting to say your honors to this commission.
We like the promotion, but it's just commissioners.
You're all honorable to me.
Mr. Winter.
There was robust argument via pleading in this matter. The executive director filed an initial motion for summary disposition. There was an initial denial by the administrative law judge, and then there was a second round of briefing and a motion for reconsideration that we filed. Mr. Moore is correct that the original pleadings did allege, and the initial notice to revoke alleged that Mr. Grant had engaged in misconduct that had an element of the charges of family violence, but that was not the law. The law that authorizes revocation under these circumstances is if an officer engages in a criminal offense involving family violence. This was thoroughly briefed, ably briefed by both our office and by Mr. Moore representing Mr. Grant. The administrative law judge considered these arguments. I don't think it's quite frankly in dispute. I don't think there is a legitimate dispute about the familiar relationship between Mr. Grant and the victim, in this case, Ms. Ramos. Ms. Ramos is, as the administrative law judge noted in his proposal for decision recommending the granting of the motion for summary disposition, Ms. Ramos was the acknowledged mother of their child. According to the PFD at page 7, Mr. Grant signed a plea agreement referring to Ms. Ramos as the victim. He stated to the investigating officer that he and Ms. Ramos were having relationship problems at the time of the response to the incident, and that he was going to attempt to get full custody of their son. I don't think there is any credible dispute based upon the facts before the administrative law judge and now before you that Mr. Grant and Ms. Ramos were in a relationship and that the child was their joint child. Under the applicable law then, this was an assault that involved family violence, as that term is defined in the Texas Family Code. And the executive director again urges that the proposal for decision be adopted and that Mr. Grant's peace officer license be revoked.
Okay, I have a question.
Yes, sir.
Did Mr. Grant plead guilty to a Class A assault?
Mr. Grant pled guilty and received deferred adjudication for, let me check the grade of the offense. One moment, please.
On page 8 of the proposal for decision, finding of fact number 2, respondent pled guilty to assault, a Class A misdemeanor under Texas Penal Code 2201, and was placed on deferred adjudication along with community supervision for 2 years. That's finding of fact number 2, page 8 of the proposal for decision.
Yes, Class A.
Okay, thank you.
Just briefly, Your Honor. Again.
Not Your Honor.
Sorry. You guys are taking me out of my element. All I would say is, as much as I would love for you all to hop right to the material facts, I think we're here on an MSJ. We have to approach that procedurally. Procedurally, regardless of what the law says involving family violence, element of family violence, the only way the respondent knows to be put on notice of what he's defending is what is pled. If the pleadings that are never amended say that it's a crime with an element of family violence, that is what I'm responsible to reply to. I'm not responsible for defending him against any potential lawsuit under the law. I believe, based on just civil procedure due process, we answered, we replied. The MSJ was based upon things that were not pled for. And I believe that is what sends us back to a contested hearing. And procedurally, if they amend their pleadings and they do an MSJ and we're back here again, then it might take the dog out of the hunt. But that's our belief on the matter, Your Honor, as we're commissioners, as we're approaching it procedurally.
Okay,
So
thank you.
Commissioners, I've got the executive director's original petition recommending revocation that was sent by the executive director's staff to Mr. Grant on the 6th day of July 2017. I think it's in your backup material. And it says, respondent received deferred adjudication for a criminal offense of assault, a misdemeanor involving family violence. That is the standard. So the original pleading does not say for a misdemeanor offense that has an element of family violence. So I guess I'll put it back on Mr. Moore and ask him what he's referring to when he refers to pleadings that had the erroneous language, which is under the old law. There's some quizzical looks. Under the old law, the commission could revoke the license of an officer who received deferred adjudication or was convicted for an offense that had as an element of the offense family violence as defined under the Family Code. Some time ago, the commission amended the regulations to provide that an officer's license can be revoked if the officer receives deferred adjudication or is convicted of an offense involving family violence as defined in the Penal Code. That indeed is what was pled in the revocation petition from July of 2017 involving family violence, not as an element of. So I guess I would ask Mr. Moore to clarify what he's referring to when he talks about the element of language.
And what page are you referring to, Counselor?
I'm looking at the actual original petition.
In the commissioner's backup packets, there's a proposal for decision. The latest live pleadings that are before them is the order, the proposal for decision, and the respondent's motion for rehearing. That's what's before them.
Okay.
Yeah, we don't.
Mr. Moore made reference to the pleadings that were filed by the executive director initiating the action, and he's made the argument that that's what I have to respond to, what the executive director puts in play. And he has made an argument that what the executive director put into play was an allegation that his client, Mr. Grant, received deferred adjudication for an offense that had an element of the offense, family violence. That's not what the pleadings that I am reviewing reflect. So that is why I have my question for Mr. Moore. The applicable legal standard is if Mr. Grant received deferred adjudication or was convicted for an offense involving family violence, then his license is subject to revocation. That's what was pled, and that's what we argued to the administrative law judge, and that is the basis for the administrative law judge's proposal.
Briefly, Exhibit E of the MSJ filed by the executive director has attached the original petition recommending revocation. An original petition is how you file any type of lawsuit. It's what puts everyone on notice as to what we need to respond to. All those people that were defaulted earlier were served with the petitions. They didn't file an answer. In this case, we filed an answer, a general denial. It's administrative, but it's also civil. We are entitled to only have to respond and raise defenses to that which we are served with. Under Exhibit E, I guess if we're counting page 1, 2, 3, well, from the petition recommending revocation, page 1 of 4, top of page 2, paragraph 2, the commission shall revoke any license if the licensee is convicted of an offense that has an element of the offense, family violence. As such, the executive director recommends that the commission enter an order revoking respondent's license pursuant to the code and commission rules. Doesn't say involved, says element of. And I just reassert our original argument.
I'm trying to remember, and maybe one of you two can help me, but isn't there a provision under the Administrative Procedure Act to where it is a request for clarification or amendment of pleadings?
Certainly, a respondent is always entitled to file special exceptions if the respondent does not understand the pleadings.
And can't you try issues? Can't you acquiesce to issues and or pleadings by trying them?
I think you can, but let me go back to what the pleading record reflects in this case. I see the language now that Mr. Moore is referring to on page 2 of the executive director's notice of the institution of revocation proceedings. On the same document on page 1 is reference to the respondent's conduct of receiving deferred adjudication for a criminal offense of assault, a misdemeanor involving family violence. So both languages in the original pleading. But I'll point out that in the executive director's original motion for summary disposition, which was filed on December 15, 2017, and to which the respondent replied and filed arguments in opposition of, as well as in the executive director's motion for reconsideration, where we re-urged the motion for summary disposition, the executive director pled and argued the accurate state of the law and the facts in this case, which is factually, Mr. Grant was arrested, pled guilty, and received deferred adjudication for a criminal offense arising from a dispute that he got in with his live-in girlfriend and the mother of his child. And under those facts, that makes the offense at issue an offense involving family violence as defined under the law. That is what was pled by the executive director in multiple pleadings filed in this case, including 2 motions for summary disposition. That was argued by the respondent's counsel very, very ably and competently in the motion practice before the administrative law judge. So both as a factual matter and as a legal matter, the executive director stands by the recommendation that under these facts and circumstances, Mr. Grant's license is subject to revocation.
And Mr. Moore, just so I'm clear, for the commissioners, your request we've heard your arguments as to why, but ultimately you're asking the commission procedurally to remand this case back to SOA for a hearing, correct?
Correct, to deny
Okay.
the MSJ, because we don't think it was the foundation of it was based on the right things. We think that they overpled what they needed to, and they should have amended. They did not. and therefore, the MSJ is improper right now.
Okay, so, and I'm looking at, the commissioners have a motion for rehearing in their packets as well. Is that in, there hasn't been a final order issued in this case, so I'm a little bit confused as to what this motion for rehearing is.
That was, Your Honor, and I apologize. Sorry, Commissioners, I'm going to do this all day, I think. The motion for rehearing was filed because I think I did not realize how this procedure worked to where we would be set for the date here. So I think the motion for rehearing was not timely, or is been filed prematurely. That will be the motion that is filed after this hearing. But it was still admitted, I think, just as our response to the PFD. The underlying theory and logic is the same. But again, the petition asserts the element of family violence along with involving. They held themselves to a higher burden and we only have to respond to what they sue for. That's our argument.
So
Thank you.
The current request from the ALJ for his appeal basically was not heard, or was not viewed, because this matter is before us to look at. When I look at it as a matter of procedure, right, and due process, I have some concern on moving forward, personally, on us moving forward on this without having the entire due process finished with what the respondent has, irregardless of I can look in here and see, and I think this is probably where it's going to go, but I have some reservation for that without having that input from the ALJ on that. So, and I also defer to my other commissioners on.
As far as the input from the ALJ on which issue?
On the rehearing, on what he's trying to say on the due process is that we, or the commissioner or the executive director, said we're going to take suspension for these particular items when that's not what was particularly pled to. I think that's ultimately the matter here in this deal.
Commissioner, I respectfully disagree with counsel's contention that the respondent was not on notice that the executive director's theory of this case is that under the facts and circumstances, the offense below was an offense involving family violence. It is abundantly clear from the pleadings that have been put on file in this case. The original petition, he is correct, it has both phrases in it. An offense involving family violence and an offense that has an element of. But in subsequent pleadings, a motion for summary disposition that was filed in December of 2017, as well as a motion for reconsideration of the ALJ's original ruling, which was filed, I believe, in January of 18. The executive director made it absolutely crystal clear that the applicable law does not require the element of finding. The applicable law only requires a determination by the trier of fact, in this case the administrative law judge, that the offense below involved family violence, as family violence is defined by statute. Family violence is defined by statute as an offense that fits the circumstances that we have here. The facts below are not, this is argument from me, and counsel may disagree, but I don't believe the facts below are seriously in question. The administrative law judge made the finding, which is fully supported by the evidence that was before him, that the victim was Ms. Ramos and she was the mother of the child of Mr. Grant. The arguments that you are hearing today were made before the administrative law judge in the motion practice. They were fully considered by the administrative law judge. I don't think there's any question that Mr. Grant has had the process that is due here. There is absolutely no abrogation of full due process under these facts and circumstances.
Can I ask a couple questions before we go on and try to move on? Because I think we're
Please.
starting to do what lawyers do. And
Please.
We've got it, guys. We've got both sides. But
And respectfully, Commissioner, just one last thing. Mr. Grant is just wanting his day in court to be heard. At this point, all the evidence that is being ruled on an MSJ that will cost him a lifetime ban is hearsay within hearsay. He just wants to be able to appear in court and tell and have due process, not be poured out and be told he can't ever be a police
I
officer.
know
again.
I'm
I
not the
apologize.
judge.
We got it. Commissioner
Yeah,
Burris?
And I know I'm not a judge, but let me ask my questions. Which actually, I'd like to respond to Commissioner Hester. We are part of the due process system. That's what this hearing is here today. And so we are doing what needs to be done for Mr. Grant to have due process. A couple questions. One is he denying that this child is his?
I don't believe I can put on any facts. I'm not a witness in the case. I just know that we have responded procedurally to this. Mr. Grant wants to testify in court to any questions that want to be proposed of him, but we're being denied that with an MSJ.
Okay. Here's my second issue. I think we're having a little bit of trouble in coming to a decision because we don't have the exhibits that you all are referring to. So I trust you, Mr. Winters, but as President Reagan said, trust but verify. And I want to make sure that we are providing Mr. Grant his due process rights. And so in looking at everything, and again, I believe the ALJ, but without having the exhibits to refer to, I can't say for sure that on reading the police report or anything that was entered into evidence by the executive director that is actually in there.
Commissioner Burris, what we can do, and we've taken direction in the past from the commissioners that anytime we had any sort of motion or proposal for decisions to not put exhibits in there, but I think certainly if one option would be we could table the current proposal for decision, granting the motion for summary disposition, and allow the opportunity to have those exhibits. And Mr. Moore, did you file a response brief to the, we could attach those exhibits that were filed on behalf of the executive director and Mr. Grant in the packet so we can look at it next commission meeting. That's an option that I'm throwing out there if there's going to be some examination of the underlying exhibits for which the proposal for decision was issued.
Yeah, and I looked at the March 2018 and the original petitions in there, but no exhibits in that either. So.
And again, we can certainly include those.
And, you know, I want to believe everything that is stated in the findings of fact and all that. But again, as being part of that due process, I want to make sure that that it jives.
I have a question before we move to table, if that's the direction that we're going. I just want to be clear, sir. Your client pled guilty to a Class A?
Either guilty or no contest, yes, to a Class A 2201 assault.
Involving family violence, is that not correct?
No, there's
Just a
nothing,
Class A?
there's no judgment, no stipulated facts, no attached SX1 plus exhibits, no record. In fact, they dismissed all of the family violence charges, and including the felony that I think it first stemmed out of. And he pled to, on paper.
Now, let me just clarify, Mr. Moore. We are not bound by the court's judgment that there was no finding of family violence. We don't have to have that. We just have to have something in front of us that shows, as Mr. Winters has stated very clearly, that it's an assault that involved family violence. And the only reason I'm bringing this up is we don't have that backup information in front of us. And I know you do, and I'm sorry, we should have asked for it a week ago so we could have reviewed it prior to today.
Commissioners, may I make a suggestion? If it's going to be the desire of the commission to defer final decision in this case to the, for example, the September quarterly meeting, I think this is where Mr. Beecham was going. We could allow, technically, Mr. Grant did not file exceptions to the proposal for decision. What he filed was a motion for rehearing. We get it, you could extend the deadline to, you know, you could give Mr. Grant and Mr. Moore 20 days from today's date, for example, to file exceptions to the PFD, where he articulates whatever complaints or issues he has with the proposal for decision. That would allow the executive director an opportunity to brief the issue in response, and we will ensure that when the matter comes up at the September quarterly meeting, that there is robust backup material for your perusal and consideration, including all of the exhibits that were filed at the State Office of Administrative Hearings by both parties.
That's certainly on the table. Not to restate it, but you can table this particular agenda item, allow 20 days for the submission of exceptions and responses to exceptions, and then you can take all that into consideration at the next meeting.
Or we could move forward with a motion and lay it to
Absolutely.
us in district court.
That's, there could be a motion, to accept the proposal for decision. Absolutely.
I think Commissioner Burris, I think people are looking to you here.
May I just say one last thing? I want us to make sure we're not convoluting the issues. There's a due process issue with regard to what exactly, so defective pleadings doesn't mean a judge can cure them later. If the pleadings are defective, your foundation to the whole house folds. Your motion for, so my first, the argument before the court, or the commission is that the MSJ is improperly granted because the reasoning behind what the judge ruled upon is not what the pleadings put us on notice of. And then we can get to the factual stuff.
Commissioner Hester?
I don't know that I necessarily agree with that statement, but I'm not opposed either to allowing the time to have, I agree with Commissioner Burris. We don't have the documents to look at. As she pointed out, part of one of my issues is because I don't have it in front of me to look at, so.
Commissioner Burris, a motion?
I make a motion to table the item, providing the necessary time for both parties to file to make any filings necessary.
Have a motion
Second.
and a second. I hate to ask for further discussion. All those in favor say aye.
Aye.
Opposed, same sign.
Opposed?
Opposed, one opposed. Actually, two.
Actually, three.
Actually, three. Okay. So, we, go ahead.
No, I'm gonna oppose also, actually.
Okay, I'm gonna vote again by hand, show of hands. Have a motion to table, this for time's sake,
Perfect.
to be taken up at a later time. All those, and it was seconded. All those in favor, raise your hand. 1, 2, 3, 4. Right?
Hey,
1,
I'm
2,
sorry, could you
3,
restate the motion?
4.
Motion is to table.
I didn't hear you.
Motion to table.
Oh, the motion's table, okay.
Motion to table. 1, 2, 3, 4. Against.
Against.
Now against.
Against.
Oh, I'm sorry, I thought you said again.
Okay, so it passes. 4 to 3.
For what? I'm confused.
It's
Good.
tabled.
It's tabled till a later date.
Oh, okay.
Giving you some time and us some time to mull this over a little more and to let you make any kind of filings you wish to make, and the executive director make any kind of filings he wishes to make, and for us to get a look at the exhibits.
Right.
Thank you, Commissioners.
Uh-huh.
Since we were referred to as judges so frequently, I just kept thinking, I don't want to be overturned. I don't want this to go on appeal and come back to me.
Oh, for heaven's sakes. Okay, Mr. Winter, we are to Ms. Villarreal.
Commissioners, the final contested matter before you is in the matter of Constable Beth Villarreal. This may be familiar to some of you. Constable Villarreal is before this commission because of a situation that arose involving her termination of an officer on her staff, one of her deputy constables. She terminated with a dishonorable discharge in June of 2012. That officer contested the F5, as is allowed by law that you're all familiar with. The contest of that F5 went to the State Office of Administrative Hearings, and the administrative law judge issued a final order requiring the constable to change the F5 from a dishonorable to an honorable. That final order was issued and became final in February of 2014. In September of 2015, the attorney representing the officer in question wrote to the executive director and said essentially, hey, this F5's never been changed. As a result of the attorney representing that officer bringing it to the attention of the executive director's staff, Mr. Beecham wrote a letter to the constable reminding her of the fact that she was obligated to change the F5 in accordance with the SOA order. And within a number of days after Mr. Beecham's letter was received by the constable, she did in fact cause the F5 to be modified in accordance with the SOA directive, with the SOA order. Several months later, the executive director issued a written reprimand to the constable. The constable chose to request that that reprimand be rescinded, contending that she did not do anything intentionally wrong and that she had corrected the matter once Mr. Beecham brought it to her attention. Mr. Vickers declined to remove the reprimand, notwithstanding her request, but he did give her the opportunity to come to this commission and address the commission over the issue. And so in June of 2016, about 2 years ago, the constable appeared before the commission and made her case as to why she thought that reprimand was inappropriate. The commission asked a number of questions of her that day. The ultimate result that day was that the commission voted to abate the reprimand and direct the executive director's staff to conduct an investigation into the matter. The executive director's staff, Captain Doug Skolak, conducted an investigation, the basis of which became a subsequent enforcement action by the executive director to suspend the constable's license based upon the allegation that the constable was untruthful to the commission in the presentation of statements that she made in June of 2016, as well as the additional basis of her failure to timely correct the original F5 as directed by the State Office of Administrative Hearings. The matter was heard by the administrative law judge earlier this year, in January of this year. There was robust, again, motion practice, closing arguments after the contested case hearing. This was an all-day evidentiary contested case hearing. Captain Skolak testified, as did several other individuals. And the final result is the proposal for decision that is before you today. The constable is represented by counsel. Counsel has written, I'm aware, has written a letter to the commission asking that the proposal for decision be accepted in part. What that PFD recommends is that that Ms. Villarreal be fined a $750 monetary administrative penalty, and the PFD further recommends that the commission assess either a reprimand, which was the original decision by the executive director before the investigation, or in the alternative, assess a one-year term of suspension that be fully probated. That's what the PFD recommends. Constable Villarreal has written to the commission and has asked that the commission assess the $750 monetary administrative penalty and issue a reprimand. At this point, the executive director is willing to concur with the PFD as to the suspension, as to the term of suspension, but recommends that if the commission determines to suspend Constable Villarreal's license, that a condition of this term of suspension be that she attend a 4-hour ethics class.
4-hour what?
Ethics.
Ethics.
I'm sorry, say again?
Ethics class, is that what you said?
Yes, sir. I
Okay.
said a 4-hour long ethics class, 4 classroom hour ethics class.
In person.
And so that is the recommendation of the executive director at this point, and we're available if you have any questions.
Is there anyone here representing the constable? Okay.
Commissioners, you have in your packets a letter that was submitted by counsel for the constable 3 days ago, 2 days ago. You should have that in your backup material as well.
I just have a question.
Commissioner
couple
Burris.
questions. Thank you. What happens with the reprimand, being the non-cop? Tell me.
If a licensee is issued a reprimand through the commission, it becomes a permanent part of their file. If you get more reprimands, additional reprimands may result in more severe action taken. But a reprimand simply is a reprimand that stays in the permanent file of that licensee.
And if she is given a probated one-year suspension, what happens?
That suspension is placed upon her license, and if it's probated, then she's just like any other probation. The licensee is placed on probation. If at any time during that 1 year they violate any stipulation of that probation, then it becomes a full suspension at that time.
But she's working.
She's
at that
currently working as the constable until January.
And I just bring this up because she argues, I won't be able to work if you suspend it.
And I want to clarify there that is a very unusual situation. There are two types of officers, peace officers in the state of Texas that are actually constitutionally elected, that the rules that govern them come through constitutional process and not just our process. That's sheriffs and constables. Since they are elected by the people and constitutionally elected by the people, the only way they can be removed is either by voted out of office, or if through a local district court, a quo warranto proceeding is filed against them to remove them from office through a district court. So if we suspend her license, be it probated, be it a suspension, that does not remove either a constable or a sheriff from their position, and they continue to serve as a peace officer. It takes a quo warranto or being voted out of office.
And I ask you these questions just for it to be on the record.
Yes.
What is actually going to happen since these issues were
Yes.
raised? She is an elected official. Like we've said, she's only going to be, her license will only be revoked if she's convicted of a felony or otherwise. That's not the situation here.
And even if her license is revoked, it still does not remove her from office. That has to be done on a local basis. And also, one thing I wanted to clarify, because I was trying to grasp this myself, when it's talking about a $750 administrative penalty, That does not come from the constable's personal funds. That is that is an administrative penalty that's assessed against the county, and the county is who would pay that fine, that administrative penalty, and not the constable herself if it's done.
Commissioner Hollingsworth.
I move that the commission not accept the recommendation of the ALJ, but instead, the commission move to suspend the license of Bethel Villarreal for a period of 1 year and be assessed a $750 administrative penalty and be required to attend in-person an ethics course prior to the reinstatement of the license.
I'll second.
Have a motion and a second. Any other questions or discussion?
Commissioners, may I ask a point of clarification?
Yes.
Is the motion on the table to impose a 1-year fully served suspension?
Yes.
Yes, sir.
Have a motion and a second. Any other discussion? All those in favor say aye.
Aye.
Opposed? I think that passed.
It did.
Mr. Winter, then the for information only.
Yes, sir. The remaining items are all informational. There are statutory revocations. These are individuals who committed and were convicted of offenses, felony offenses, which by law result in an immediate, upon conviction, statutory revocation of their peace officer and jailer telecommunicator licenses. Also listed are individuals who received deferred adjudication for felony offenses, resulting in automatic statutory suspensions of their licenses. In addition, there are term and permanent voluntary surrenders. These are individuals who were under some criminal charge and negotiated with the prosecutor for the surrender of their peace officer license. Most are permanent, but there is one term surrender. And in addition, you have for your information the names of individuals who have received reprimands from the executive director for failing to complete their legislatively required continuing education requirements, and also for failing to comply with other administrative requirements of the commission by rule.
Thank you. Thank you, Mr. Winter. We'll move to agenda item number 11, which is receive public comment on any topic without action. I don't have anybody signed up to speak, but if you'd like to address the commission, come on to the podium, identify yourself. Look at them rush down here.
They're hungry.
Item number 12 is executive session, but we are not going into executive session today. So we will move to agenda item number 14, where we'll be adjourned until September 6th, 9:30, right here.
The thing about it is that he was basically arguing that the commission
I could
argued
see
too
that
much.